And yet people are prepared to say that there's influence in these courts, and therefore if there's influence in these courts, then there will be influence in the CCJ. I think that's a bridge too far for someone to cross without providing a singular piece of evidence to substantiate the issue of influence. And in addition to that, Sean, another point that I would really want to make is simply this, that while the CCJ spoke of the financial debt owed to the court by the government, she also spoke about the significant progress made by the court in making access readily available and to revamp and to speak up and to put up the system, get the system working better for the thing. And as an advocate of over 30 years experience in these high courts, I have not encountered the sort of things that I'm hearing bandied about by everybody, including lawyers, about the court this and the court that and politics this and politics that. And it's a very fair criticism because it's a major decision. And if you're going to make a major decision like that, you need to be able to give the people credible facts.
But not just that, Tony. I don't think majority of them are hearing, including my good friend Kenny, and I hope you're listening. I have a hard time. Many of them coming to tell me about, oh, they're so patriotic and they believe in the independence of this. What a load of rubbish. If you're going to tell me that we are unable to govern our affairs, because what you're telling me is that there's a lack of trust. What you're saying, you're seeing politics in everything, and because it suits your favor. I want to read something Mr. Forbes Burnham, the late Forbes Burnham. He said one of the reasons for the establishment of an appellate court in the Caribbean, because at that time there were several leaders, including the late Forbes Burnham, had believed that the British Privy Council had too much legal power over the countries in the Caribbean. They also lamented that the independent Caribbean countries are the only remaining ones in the former British Empire that relied on the British Privy Council for appeals. Another reason was the refusal of the Privy Council to allow capital punishment for persons convicted of murder in Caribbean states, even though majority of the people, now that's a key point, even though a majority of the people in the relevant jurisdictions supported the death penalty. And he quoted that in the 1993 case of Pratt versus the Attorney General of Jamaica, the Privy Council ruled that persons imprisoned on death row for more than 5 years should have their sentences commuted to life imprisonment. The above suggests that there was a clear need to have a legal, permanent, regional institution to authoritatively and definitively interpret and pronounce on laws in the region. The Caribbean Court of Justice is intended to be such an authoritative institution. It is critical to the success of the CARICOM and now that's the point there I thought, Tony. It is critical to the success of CARICOM and the regional integration. And there's something else I'll also read here.
But Sean, before you do that, let me just jump in there.
Go ahead, please.
Forbes Burnham had incredible foresight.
Right.
Because, and we have had West Indian commissions, CARICOM commissions from as way back as 1992 that has visited the issue of the CCJ. In 1992, the West Indian Commission that was established by CARICOM, headed by Sir Sonny Ramphal, Philip Nassif and others, I don't remember who the other one was, published their recommendations to the people of this country in their report called The Time for Action. And they said this.
I remember that.
And they said this. First of all, we believe that the time is at hand for establishing the Caribbean Court of Appeal. What in an integration context we would prefer to see to call the CARICOM Supreme Court. We do not wish to minimize the issues which have characterized the discussion. Indeed, we shall address some of them. But we are strongly of the view that we cannot, like characters in the Chekhov play, go and sit in around tables, forever discussing the pros and cons of action, and in the process forever deferring it. Prophetic words from 1992.
That's right.
Right? We believe that the CARICOM decision was the right one, even in the context of an appellate jurisdiction alone. But the case for the CARICOM Supreme Court, with both a general appellate jurisdiction and an original regional one, which is now the Treaty of Chagarama, is now overwhelming. Indeed, it is fundamental to the process of integration itself. And the court the commission recommended that at paragraph 12 of its recommendation, that as a deepened number 12, as a deepened element of that as a necessary element of deepened integration, there be a CARICOM Supreme Court with original jurisdiction in matters arising under the revised Treaty of Chaguaramas, including the authority to issue orders enforcing the implementation of CARICOM decisions. And with an appellate jurisdiction from the courts of member states, the court's jurisdiction should be designed to assist the evolution of CARICOM law and its universal enforcement. Now, 10 years later, Sean, 1992 to 2002, the Constitutional Review Commission of Antigua and Barbuda, that was chaired by Sir Fred Phillips QC. The members were the Honorable Dame Bridget Harris, Sidney Christian QC, Professor Ralph Carnegie, who was one of the greatest constitutional scholars and professors at UE, sat on this commission. They issued their report at page 104 under the heading Caribbean Court of Justice. They say, and I'm going to read it, Sean, if I may.
Yes, please.
Other commentators expressed the opinion that it is one of the incidents of independence that countries liberated from colonialism should have their own final courts. This is the view shared by the Commission, and it happens to be the view recently expressed by an outgoing senior lord in the English House of Lords who sits in the Privy Council, Lord Brown Wilkinson. In an interview given in May 1999 to the Lawyer English publication, Lord Brown Wilkinson bemoaned the fact that the Privy Council was spending 25% of its time hearing appeals from the Caribbean, quote unquote, quite a fantastic number. He complained about the workload of the Privy Council and came out into the open to comment that, quote unquote, the ultimate court of appeal of a state should be in that state, staffed by citizens of that state, close quotations. The Commission hopes Antiguans and Barbudans will not be caught napping. This is 2002, Sean. In a situation where the British government gives them marching orders from the Privy Council.
Can you believe that? Yeah.
On the ground that the Caribbean now has plans to establish its own court of justice and that our Privy Council days should come to an end, we should then tragically have overstayed our welcome.
And the thing is, Tony, what bothers me the most is that when I hear people and I see T-shirts, they lack trust. That's not saying much for us. It's not saying much for our independence or who we are. So then I'm asking, the question is, should we have faith in anything? And I want to read something that was sent to me, is where the late Dame Bernice Lake QC, where she said that the Caribbean people lack confidence in our domestic legal system and yearn more for justice than they yearn to be able to boast of having their own appellate court. Now, the writer said, it is regrettable that the writer, that Mrs. The late Dame Bernice Lake, purported to validate the lack of confidence as being not merely a feeling of Caribbean people, but based on statistics. The writer said, when it is appreciated that nearly 90% of the cases going up from the Court of Appeal to the Privy Council are reversed, it is a matter of numbers, not feeling. It is inferred that the Court of Appeal to which the writer was referring was that the Eastern Caribbean Court of Appeal, the statistic the writer uses is utterly wrong. Statistics and appeals to the Privy Council are freely available at, you could go to privy/council.org.uk. And the last 2 years for which the Privy Council statistics had been posted are 2006 and 2007. Those statistics reveal that in 2006, the Privy Council disposed of 6 appeals from the Eastern Caribbean states. 4 appeals were allowed and 2 were dismissed. In 2007, the Privy Council disposed of 9 appeals from the Eastern Caribbean states. 5 were allowed and 4 were dismissed. It is therefore egregious to propagate the statistics that 90% of the decisions of the Court of Appeal of the Eastern Caribbean Supreme Court are sent to the Privy Council are reversed. Wow, that's a big one there, Tony.
It is, and
that's a huge one.
And she was challenged. She was challenged on this by a senior counsel from Belize.
But that's a big one, man.
Yes, so, and when you read the other sections, you'll realize that what the lawyer was arguing, that not only was it false to suggest that 90% of the cases were overturned, but that the Court of Appeal in the United Kingdom had a greater rate of its decisions being overruled. than judgments from the Eastern Caribbean Supreme Court.
But I mean, I can't remember how many years Dame Lake has passed. But isn't that the same thing? What she's saying though, Tony, a lack of confidence in our domestic legal system. And so what happened? Where does this lack of confidence come from?
It comes from misinformation.
Okay.
You have the classic example in this case where the argument was being made that 90% of the Court of Appeals decisions were being overturned, and therefore it was an indictment in the confidence of the court. Then Dennis Barrow, SC from Belize, responded and using the statistics from the Eastern Caribbean Supreme Court and from the United Kingdom, from the House of Lords and the Privy Council, and showed mathematically that the British Court of Appeal had a higher rate of overturn than the Eastern Caribbean Supreme Court. The lack of confidence is created, or the appearance, or the talking points on lack of trust and confidence is premised on misinformation, and is premised on, in many cases, false information.
But Tony, isn't that like when we listen to talk shows? If you come on and you start to chat a bunch of rubbish, and you look passionate and everything, oh, he had a great speech, he talked good, boy, he saw good. And if you could have somebody even keel and they have a substantive factual argument, all of a sudden that's dispensed with. So we still have that emotional attraction.
I heard people say that about Queen Williams. And I was astonished at her speech, especially when she tried to indict Gertrude Tom for sitting, quote unquote, in one of the Court of Appeal cases in the last election. Interestingly enough, Gertrude Tom sat on the case involving the registration of voters, which Gaston Brong lost. But what was most egregious about that misinformation that was set out there was that at the beginning of the hearing, Gertrude Tom indicated to all the lawyers, Russell Martineau, Justin Simon, myself, Samantha Marshall, that she was the former Attorney General. Did anybody have any objections? And everybody said no. And so the appeal was heard, and Gaston Brong lost. How do you use an example that Gaston Brong lost to suggest that there was somebody on the court who sort of used the political influence of her past employment to assist somebody, when in fact it turns out she asked if anybody objected to her, they said no. And secondly, Gaston Brong lost the case. So how does that become a pillar upon which you mount that partisan blind, how should I put it, ambush on the court? I mean, it was, to me, a really disturbing experience. But you see, I don't know if she's a lawyer. But when lawyers put out this vague, generalized argument about trust and take about access, someone says, a lawyer says, there's nothing to suggest that because the CCJ is closer, it means that more people are going to take their cases to the CCJ. But Sean, let's pause there. If we accept in the debate that the travel and the cost and the expenditure of going to the Privy Council is a hindrance, and it is. Death penalty cases go there because many of them are funded by trust funds. Government goes because they have the money. Others like Tim Hector and Eloy De Freitas go on matters of strong constitutional principle, etc. But the average man cannot afford to go because of the cost. If we accept the cost is lower, if we accept that you can now access the CCJ via video link, if you can now accept that it costs nothing to file documents with the CCJ, it is disingenuous to suggest that people will not go, or there will not be a greater turnout of people wanting to go to the CCJ. There's something fundamentally wrong with that.